This is the Securities Regulation Protecting the Investor video lecture. It will be broken down into two parts, Part 1 and Part 2. Part 1 will be an overview of securities regulation and specifically about the Securities Act of 1934, or 33, Securities Act of 1933, and with the amendments from the Jobs Act. Part 2 will be over the Securities Exchange Act of 1934. Well, why does the government need to protect investors? The answer is simple. It's greed. People without money will find ways to get the money from people with money. And the old adage, a fool and his money are soon parted, is apropos. The laws protecting investors, these are the big ones. Securities Act of 1933, again dealing with the primary market, the initial issuance of securities. The Securities Exchange Act of 1934, dealing with the secondary market for securities, the subsequent buying and selling of securities, the trading of securities. The Blue Sky laws, which we will not spend any time on, these are state laws. Our focus within this lecture and within the outline is are the federal statutes. The Blue Sky laws, every state have their own laws. Many of them have been preempted by the federal securities laws, the Securities Act of 1933 specifically, and the Jobs Act. But before the federal legislation, all legislation was state. It was not effective. As we talked about the Private Securities Litigation Reform Act of 1995, the Sarbanes-Oxley Act, which we've discussed already, of 2002, and the Jumpstart Our Business Startups Act of 2012, i.e. the Jobs Act, which modifies requirements of the 33 Act, the 34 Act, and Sarbanes-Oxley. Let's first look at the Securities and Exchange Commission. The Securities and Exchange Commission was established as the federal agency with jurisdiction over the securities, the issuance of securities and the trading of securities, and the stock exchanges. It was established by the Securities Exchange Act of 1934. They have, the SEC has jurisdiction and administration to assure the fairness of the trading of securities and the reporting. They also cover tender offers and proxy solicitations. The SEC regulates the trading of securities on the national and regional exchanges. Many of the regional exchanges have been bought out by the national exchanges. And also for the over-the-counter market. The over-the-counter market is basically peer-to-peer selling, if you will, shareholder-to-shareholder selling, if you will, maybe through a broker, generally through a broker, where there is a bid price, an ask price, and a bid price. These are for generally smaller companies. There is a federal administrative agency called FINRA, the Financial Industry Regulatory Authority, and FINRA regulates the broker-dealers operating the over-the-counter market. The SEC regulates or investigates security fraud, regulates the activities of security brokers, dealers, and investment advisors, supervises activities of mutual funds, recommends administrative sanctions, injunctive remedies, and criminal prosecution. Now, they don't actually do the criminal prosecution. They will simply make a referral to the Department of Justice for violators of the federal securities laws under the fraud section of the Criminal Division of the Department of Justice. Well, what is a security? We know generally what a security is. It's more specifically defined as any note, stock, treasury stock, bond, debenture, evidence of indebtedness, certificate of interest or participation in any profit-sharing agreement, investment contract, or in general, any interest or instrument commonly known as a security, or any certificate of interest or participation in, receipt for, or right to subscribe to or purchase any of the foregoing, meaning an option or stock rights. The most obvious of all of them are stocks and bonds and debentures and limited partnership units. You can boil this down. You can boil this down to a person invests money or property in a common enterprise or venture, and the investor reasonably expects to make a profit primarily or substantially as a result of the managerial efforts of another. In fact, under the U.S. Supreme Court case, SEC versus W.J. Howey, an investment contract, which is generally listed as a security, was determined to be a security when W.J. Howey Corporation, rather than issuing stock or securities for the operation of orange groves in Florida, simply gave quitclaim deeds for the land, some land containing orange trees. That way they didn't register the securities. The court held that this was an investment contract because W.J. Howey was responsible when they sold the quitclaim deeds, the land. They also had the buyer execute a management agreement that gave W.J. Howey the exclusive managerial rights to the orange grove for the protection of the operation of the sale of the produce from the taking of a management fee or operating fee and giving the residual to the owners. The court held that that was an investment contract, and therefore as investment contract they were required to be registered, and by failure to register them as securities with the Securities and Exchange Commission, they had violated the Securities Act of 1933. The basic requirements under the Securities Act of 1933. First, an issuer must register securities to be offered to the public unless the securities are exempt. And second, with the registration of these securities, a registration statement is required to be filed with the SEC before any new securities can be sold. This was what was not done in W.J. Howey. Looking briefly and generally at the registration process. And keep in mind that this registration process has been changed somewhat by the Jobs Act. First, the issuer, and keep in mind this is the primary market, meaning the initial sale of a security, we generally would think of as an initial public offering. The issuer must file a registration statement with the SEC. That registration statement is a substantial document. It tells everything about the corporation, about the officers and directors. It gives audited financial statements. It gives projections of profitability and the use of the money. After the registration statement is filed, the SEC has 20 days to act on the registration statement. Now, this is the pre-approval stage, in which the issuer is limited as to what it can do in terms of its sales and marketing effort. During this pre-approval stage, the issuer cannot sell any securities, but may solicit or receive oral revocable offers, not irrevocable. Revocable, which basically means you can undo it, for the purchase of the securities. Second thing, during this pre-approval stage, the issuer can issue a red herring or a preliminary prospectus. It's called a red herring prospectus, which contains red ink that the registration statement has been filed but has not yet become effective. And the third thing it can do in terms of marketing, it can place a tombstone ad in the financial newspapers. Think of Barron's, Wall Street Journal, etc. These are not offers. Tombstone, because it's got a black border, a hard black border around it to give the notice. It basically says, stay tuned. Look out in the future for these issuances of these securities, and these will be the underwriters that will be selling them. If you do, anything other than those in terms of marketing and selling, then you violated the 33 Act. After approval of the registration statement, it becomes, meaning it becomes effective. The issuer can advertise, solicit for sale for the securities, and they must give each solicited investor a final prospectus. Keep in mind, if after the registration statement is filed and the SEC has 20 days to act on it, if they don't act on it, it becomes approved. You can tell by all of this that there's a potential problem and conflict with the use of computers and the use of the internet to solicit. We'll talk a little bit later on about Regulation D and how the internet affects it. There is a situation when securities are exempt under the 33 Act, no registration is required. In very limited situations. The issuer is a government body or nonprofit organization. The registration requirements does not apply to any issuer that is a bank, a savings institution, a common carrier, or a farmers cooperative, and subject to other regulatory legislation. Doesn't apply to commercial paper having a maturity date of less than 9 months. This is because it's so short term. Doesn't apply to stock dividends, stock splits, and securities in connection with corporate reorganizations. There are some exceptions, however. And doesn't apply to insurance, endowment, or annuity contracts. or when the issuer's offer of up to $5 million in securities within a 12-month period to test the water for potential interest. This was Regulation A. It's been modified by the Jobs Act, increasing the $5 million under Regulation A to $50 million. All that is required is just filling out a fairly short form called a circular. Certain transactions are exempt from registration under the 33 Act. Briefly, on each of these, intrastate offerings, where all offerees and residents of the state in which the issuer is incorporated and performs substantially all of its operations and shares must be at least 9 months before the resale by the investor, meaning the investor, once they acquired, this intrastate investor has to hold on to those shares at least 9 months. You can see substance over form being applied here. Keep in mind that the federal legislation, Securities Act, deals with protecting on a national level. It is the interstate nature of it. Remember, under the Commerce Clause of the Constitution, that gives the SEC, gives Congress the power to regulate interstate commerce. Well, if these issuers are within the same state as the shareholders, the investors, then this is an intrastate activity and should be regulated by the state. It would be under the blue sky laws of the state. For example, in Tennessee, under Tennessee's blue sky laws, no registration on an intrastate issuance if it's no more than $500,000 in a year. That's $500,000 is not a large issuance. Probably the most important before the Jobs Act, anyway, and even after the Jobs Act, is Regulation D issuances. And the Regulation D has certain rules, Rule 504, 505, 506, and these deal with different variations on a theme of the offering. But Regulation D is more private-oriented. And these private offerings, meaning they're not public offerings, you target the investors that you want to sell your shares to. When you have these private offerings of any amounts of securities to accredited investors, these are the targeted investors. These are the persons generally that don't require protection by Congress. Those accredited investors are natural persons with incomes over $200,000 and a net worth over $1 million. Or if the investors are represented by purchaser representatives like pension trust administrators, investment companies, large corporations, and so forth. Also persons who have particular expertise within finance and investments. All right, these are accredited investors. You can sell to as many of those as you want under Regulation D, up to the dollar limits for the issuance. But you cannot solicit from or sell to no more than 35 unaccredited investors. Now, 35 is a very small number under Regulation D. And these are persons who do not have the financial expertise or the financial or economic wherewithal to show that they have an understanding. 35 is a very small number. Now, any solicited investors have to be given the same information have to be given a prospectus, which is basically it's a short form, simple language, non-legalese of the registration statement. Contains the financial statements, information about the company, information about the management of the company, and the projections. Now, under Rule 505, this offering is $5 million limit, again, pre-Jobs Act. But Regulation D, under the other rules, can go up to $20 million, which is a large amount of money. So from understanding all this about Regulation D and these intra-state or these private offerings, you can see what the problem is for using the Internet in order to secure the funding. The Internet allows issuer to cast a broad net, but in casting the broad net, you necessarily you obviously gather into the net more than 35 unaccredited investors, which blows the Regulation D coverage and throws you into full registration mode, which is very expensive, especially for small issuances. You have to be very careful using artificial intelligence under Regulation D to make sure that you are not soliciting from. Now, you can use the artificial intelligence to basically ask the information so the computer program through this artificial intelligence can make the determination as to who is or who is not an accredited investor. Hence, you can get where you need to go. Also, you can use the Internet as a way of distributing the marketing information, a prospectus, for example, or a registration statement for a full registration. The Regulation A issuances, this is I referred to them a little earlier. These are small issuances of no more than $5 million. Again, this has been changed by the Jobs Act to $50 million. And this is generally to test the waters. It's Regulation A as it stands. It's $5 million within a 12-month period. Limited information to the SEC. It's in a circular form. It's a sheet of paper, both sides, and doesn't require a great deal of time or a great deal of expense. The question is, are there investors out there who are interested in it? If they're interested in it, then we can do the full-blown registration and bring in a lot more capital. And then lastly, exempt transactions, the small issuances, less than $500,000 without advertising, where the investor must hold securities at least 2 years, and the SEC requires Form D to fill out. And keep in mind, Form D is under Reg D is basically it's a short form, right? It's more of a booklet rather than a full-blown book that would be required for a full registration statement. Briefly on the Jobs Act, keep in mind that in 2012 we were still dealing with the recession, the deep recession, or the Great Recession as it was called, and we needed to have more jobs created. There finally became an awareness that small firms created the vast majority of jobs in the United States. So Congress, and the Republican Congress, even with President Obama as the person who actually agreed to this, wanted to do some things, take some measures that would increase the ability of small firms to raise capital, and by raising capital also increasing job creation. Now, I'm not a fan of the Jobs Act, very little of it, because I think the purpose of the 33 Act and the 34 Act were circumvented. I think that the purpose of those acts was protecting investors, and I think that you're going to see from what we have to say now is that we're getting away from it. We're creating greater risk in the securities market. The Jobs Act radically changed the raising of small amounts of capital and gave leniency in raising capital and administrative and legal burden for emerging growth companies. It basically is backing off for the smaller companies, the smaller public companies. It's backing off on the requirements of Sarbanes-Oxley reporting or the reporting requirements for public companies under the 34 Act. As a general review, and this is only a general review, on Little Rooms, I have the full Jobs Act that you can read. I also have other material on there as well that compares the Jobs Act with Securities Act of 1933 and the SOX and Securities Exchange Act of 1934, whatever you want to read on it. We have a new concept called emerging growth companies, EGCs. And these are small issuances, or small issuers having no more than $1 billion in revenue per year. The Jobs Act exempts emerging growth companies from some of the Securities Exchange Act reporting requirements, the annual reports, etc., quarterly reporting, and material events reporting, and also of particularly of Sarbanes-Oxley's Section 404 internal controls requirements. Secondly, the emerging growth companies are allowed to use crowdfunding, which is a concept that's been around. Think of the internet and the use of Kickstarter to raise capital. Now, Kickstarter heretofore was simply if you like our idea, send us some money, make a contribution. You're not going to get any stock. You're not going to buy any securities. Just make a contribution, just because you want to be a part of it. Now, you can use Kickstarter. Emerging growth companies can use Kickstarter as a crowdfunding, and there also are other means set up by the Securities Exchange Commission. And the SEC fairly recently issued new regulations under the Jobs Act for crowdfunding. The crowdfunding allows an emerging growth company to raise up to $1 million each year, provided that the issuer, the emerging growth company, still maintains that status as emerging growth company. But no more than 5 years from the date of the initial issuance of securities under the crowdfunding. So I want you to think in terms of how a new franchisor might use it. You have these restaurants or these businesses, for example, like automobile services and things of this nature. You can use, through crowdfunding, you can raise the $1 million a year that you use the seed money, and you can borrow the rest from the bank or other sources. Now that will generate a way of growing. There are limitations in this crowdfunding approach, limits on the purchases. So an investor, through crowdfunding, which basically is, buy our stock. We're not going to tell you anything. We're going to tell you very little about our company. We're not going to have financial statements. Maybe we don't have financial statements. If we've got financial statements, we'll give them to you. But if you're so small, then we're not going to require you to have financial statements. Anyway, the investor is limited to $2,000 or 5%, whichever is greater, for persons are earning or a net worth of up to $100,000. All right. So, if they have more earning or worth more than $100,000, then they are able to invest $10,000 or 10% of their earnings, whichever is less. Third, the firms with total assets of $10 million, but no but no more than 2,000 total shareholders, or 500 unaccredited shareholders, do not have to register their securities with the SEC, meaning they're not going to be public. You get the benefit of a public corporation, being a public corporation, but you don't have all of the hassle of the SEC reporting requirements. Generally, under the 33 Act and the 34 Act, if a company has both total assets of $10 million, which is not a whole lot, plus 500 unaccredited investors, or 2,000 total investors, if you had both of those, then you are required to be registered. I'm sorry, let me rephrase that. Under the 33 and 34 Act is a combination of the two. All right? It was a combination of the $10 million of total assets plus the 2,000 total shareholders. It did not contain a requirement of unaccredited investors. Okay. Number 4, Regulation A was changed the dollar limit from $5 million to $50 million, which to me creates a substantial amount of risk. And lastly, on this general overview, it lifts the ban on general solicitation of advertising in specific types of private placements. Basically, it gives a much broader marketing of the placements. You can cast a broader net, if you will. We talked about the problem under Regulation D of using the internet to cast the net, and when you're bringing in 35, you could not solicit from more than 35 unaccredited investors. And here we allow it to cast broadly, as long as the companies don't sell. Right? You can provide this information. For example, under the old Regulation D, I talked about this in terms of making the determination as who is accredited and who's not. Then you could not give the prospectus to an unaccredited investor, at least no more than 35. Here you can do that. You just can't sell. You can't sell to no more than 500. Again, that was just a simple overview of the Jobs Act. I would encourage you to do some outside reading as well. Let's look at liability under the Securities Act of 1933. We talked about the requirement to register the securities. Section 11 provides liability for failure to register the securities. It imposes this liability on both the issuing corporation and its directors. The plaintiffs can be both the government and any persons who acquired the shares and suffered damages as a result, meaning this gives a private, the 33 Act, Section 11, gives a private right of action to investors who were injured. Secondly, the Section 11 provides liability for material errors in the registration statement. Errors and omissions of material facts. What is material? It's material, a piece of information is material if a reasonable inspector would want to know this information in making his or her decision. It would not be an absolute necessity. It's something they would want to know. It's significant enough they would want to know. For these material errors, liability is imposed on the issuing corporation, its directors, its underwriters, and anyone who signed or provided information that was false, but the information was incorporated into the registration statement. Think in terms of appraisers. Think in terms of the auditors. Liability also for the accountants, meaning the auditors, who do not use due diligence, meaning they don't follow generally accepted accounting principles, they don't follow generally accepted auditing standards. And their lack of due diligence was something greater than simple negligence. Right? Something greater than simple negligence. Gross negligence, recklessness, for example. The plaintiffs are any persons who acquired the shares and suffered damages as a result. There's no requirement that the plaintiff actually prove that he or she relied on the material false statement. Right? You don't have, that's not an element of the proof. It can be used as a defense by the defendants. And we're not liable to this person because this investor, this plaintiff, because the plaintiff didn't rely on it. We may have made a material misstatement of fact in the registration statement, but you didn't rely on this information in making the investment. I.e., the defendant has a rebuttable presumption of reliance. But it's the defendant's burden of proof. There are criminal sanctions for fraud and aiding and abetting against the officers, directors, underwriters, appraisers, and accountants. Aiding and abetting is the assisting in committing the fraud. Now this ends my lecture on the general overview of securities regulation and regulation in Securities Act of 1933. The next lecture will deal with the Securities Exchange Act of 1934 and fraud and insider trading.